Greetings, this is Christine Van Pelt on Gibson County, Indiana, State Coordinator and Lead Recording Secretary for the Indiana Assembly, and we are continuing with Brent Allen Winters, Declaration of 76, United States Constitution, a common lawyer comments, clause by clause. Alright, where we left off. Section 2, Clause 2. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Comment. The Supreme Court's original jurisdiction in cases affecting foreign governments and their official representatives, and those cases in which a state shall be party, means that plaintiffs must bring such cases to the Supreme Court first. In all other cases, the Supreme Court has appellate jurisdiction, meaning that these cases are tried first in a lower court and may come up to the Supreme Court for a review unless Congress has carved out an exception denying the general rule following appeal. Because this clause gives the Supreme Court original jurisdiction over law and fact in some cases and the right to review facts on appeal in others, the Supreme Court, before Chief Justice Marshall Marbury opinion, impaneled the jury to review the lower court's findings of fact, because the Supreme Court is a co-equal power with Congress, both being direct creatures of the Constitution. Congress has no right to take away or change the Supreme Court's original jurisdiction, but it can carve out exceptions to the right of appeal to that court and fix the conditions one must meet to present appeal to it. In sum, our Constitution gives Congress great power over procedure, jurisdiction, and even existence of all federal courts save the Supreme Court. Section 2, Clause 3. The trial of all crimes, except in cases of impeachment, shall be jury, and such trials shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Comment. This clause demands that the trial of all crimes shall be by jury, the feature around which our common law tradition turns and holds our freedoms in balanced orbit. Our Constitution nowhere explains trial by jury because the common law jury in all of its right workings was as familiar to the American of that day as was the curve of his own child's cheek. The right was dear. Any inconvenience to government was no concern. The framers would not have thought it too much to demand that before depriving a man of his liberty, the state should suffer the modest inconvenience of submitting its accusation to the unanimous suffrage of 12 of his equals and neighbors. Blackstone, rather than a lone employee of the state. Blakely v. Washington, 542 U.S. 296, 2004. The Supreme Court upheld the right to trial by jury, appealing to the common law tradition, our founders' intended standard for interpreting our Constitution. Our founders said the court intended common law's separation of powers not only of our courts from the other two branches, but even within each court between judge and jury. Though shocking to constitutional sense, judges increase a defendant's punishment because he demanded his right to trial by jury. It is unconstitutional, however, to punish anyone for enjoying the right because doing so chills its use. Amendment 6's guarantee of right to trial by jury, said the court, allows only the jury, never the judge, to determine all facts necessary to setting just punishment. To hold otherwise allows the judge unconstitutional power. A judge, continued the court, may impose a sentence solely on the basis of the facts reflected in the jury verdict or admitted by the defendant. At the least, our right to trial by jury means every defendant has the right to insist that the prosecutor prove to the jury all facts legally essential to the punishment that should end the matter. The framers' plan for criminal justice is the common law limit of government power by clear division of authority between judge and jury. In sum, the Supreme Court identifies our Sixth Amendment right to trial by jury with the common law right, holding that the jury are a pillar of our common law tradition, distinguishing it from the civil laws, codes of admiralty, canon, and administrative law. The jury is the only anchor that can bind government to its constitution. Thomas Jefferson. The verdict of the common law jury, impaneled as a sampling of the parties' neighbors, drawn by lot, and sitting as a court of judges, looms above all three branches of government concerning the case the jury must decide. Although the jury is called master of the facts, the court master of the law, the jury remain master of both the facts and the law in two respects. The jury applies the law to the facts or disregard the law. If wrong in its application to the case before them, if the jury feels that the law is unjust or that exigent circumstances justify the actions of the accused, the jury has the power to acquit, and the courts must abide by that decision. U.S. v. Moylan, 417, F. 2nd, 1002, 1004, 1972. In addition, the pages of history shine with the jury's exercise of its prerogative to disregard instructions of the judge. U.S. v. Daughtry, 473, F. 2D, 1113, 1139, 1972. Indeed, the authority and power of the juror is to either allow or forbid government enforcement against the defendant. The juror's power is never to brook lawlessness, but to bar, in each case, the lawlessness of government and other powerful parties. The common law principle of supremacy of the jury over all of government in particular cases governs in the federal courts as well as in each of the several states' courts. See Cooley 21. See generally Duncan v. Louisiana, 391 U.S. 145, 147 to 48, 159 to 62, 1968. For the Supreme Court's application of trial by jury in Louisiana, a civil law jurisdiction, before Duncan, Louisiana had followed her state constitution, weighted toward the Roman civil law, granting jury trials only in cases allowing the death penalty or jail at hard labor. The juror must remember that our common law and constitution not only bars government from doing directly that which it forbids, but also from doing directly by otherwise constitutional means that which our Constitution forbids. Let me reread that. The juror must remember that our common law and Constitution not only bars government from doing directly that which it forbids, but also from doing indirectly by otherwise constitutional means that which our Constitution forbids. In short, if a guilty verdict appears to a juror to be constitutional, but results in its violation, he must hold out for a verdict of not guilty. Where the judge's instruction concerning the law's application requires the juror to violate his conscience, his oath never binds him to follow that instruction. Indeed, truth binds him to do right. No oath binds any man to do wrong. Once a person understands that his oath demands an unlawful act, law demands that on that point he repudiate his oath. In short, an oath requiring a wrong result is unlawful. See example, Westminster Confession, chapter 22. The common law jury are traceable as far back as the early continental Anglo-Saxons and Danes. Its principles are discernible even further back in history. The common law requirement of 12 petit jurors conforms to Christ's example of assembling the same number called disciples and appointing them to be witnesses of his ministry. From the days of John the Baptist until his resurrection and ascension, an odd number of disciples were unnecessary because, as with common law's 12-person trial or petit jury, unanimity, not a majority, was required of these 12 witnesses to the life, resurrection, and ascension of Christ. See Acts 1:21-23. The early common law jury were foremost 12 witnesses. That the disciples understood the necessity of the number 12 is seen in their determination to replace Judas. See Acts 1:15-26. Without doubt, the number 12 bears significance in Scripture. However, nowhere by overt words does the Bible tell out the significance of the number 12, but nonetheless gives instances plenty revealing that the number 12 has to do with rule and ruling. In short, the jury's judgment of fact is the final rule satisfying due process, the law of the land. See Brent Allen Winter's Excellence of the Common Law, subsection 4.3, and accompanying notes expositing 1 Corinthians 1:1-6, and discussing the ancient Hebrews local trial court and jury called the unauthorized bench of 12 idiots. 1810, I would say. I'm not really sure what that is saying. I.e., each acting on his own authority delegated direct to him from God. Though the Anglo-Danes and Celts held the agreement of 12 men to be an accepted measure of satisfaction, i.e. enough, during Rome's occupation of Britain, they later discarded it. The Danish migrations then re-established it in the island. Though its origin remains beclouded, the significance of the number 12, no more and no less, respecting the trial jury, has never waned, remaining unsurpassed, says Chesterton, in its efficient reliability, standing on good precedents. Determining the guilt or innocence of a man is too important to be trusted to trained men. If the country wishes for light upon that awful matter, it asks men who know no more law than I know, but who can feel the things that I felt in the jury box. When it wants a library cataloged, or a solar system discovered, or any trifle of that kind, it uses up its specialists. But when it wishes anything done which is serious, it collects 12 of the ordinary men standing around. The same thing was done, if I remember right, by the founder of Christianity. The jury of 12, drawn at random, working as a panel of trial judges over the facts and application of the law and requiring unanimity, is from earliest known times been the mainstay of judging amongst the continental Teutonic tribes, says Blackstone, even into the 18th century. To sum up, the common law has always demanded the agreement of 12 jurors, knowing that nature's God is never double-minded. Though jury unanimity never assures the right verdict, anything less is presumed to have fallen short of truth. See this handbook, U.S. Declaration of 76, sections 2022, and comments. The common law jury gives a steadiness to a country unachievable by any other means. By any fair reading, the words when the crime was not committed within any state, the trial shall be at such place or places as Congress may by law have directed, means in such cases only Congress can dictate the place of trial. Section 3, Clause 1. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. Comment. Treason, says Joseph Story, is generally deemed the highest crime which can be committed. Moreover, he continues, if the crime of treason be indeterminate, undefined, that alone is sufficient to make any government to degenerate into arbitrary power. Thus, treason remains a capital crime among all nations in fact, if not in law, because one act of treason can betray an entire country into enslavement. Of the 4 kinds of crimes the Constitution empowers the general government to punish: treason, counterfeiting the securities and current coin of the United States, piracies and felonies committed on the high seas, and offenses against the law of nations. It defines only treason. As a matter of our Constitution, treason is impossible to prosecute without Congress's identification of an enemy. And Congress's identification of an enemy is impossible without its formal declaration of war. Bottom line, treason can only occur in time of congressionally declared war. Keep in mind, treason against the United States is distinct from treason against one of the states of the United States. Most state constitutions make treason against the state a crime. Only 2 men have been convicted of treason against the state: Thomas Dorr against Rhode Island in 1844 and John Brown against Virginia in 1859. The words "shall consist only" narrow the definition of treason against the United States. This clause calls the United States "them," referring to any individual state of the United States or a combination thereof. Indeed, treason against any one of the states united is treason against them all. But further, this clause bars conviction of treason against the United States on confession alone, unless the accused confesses in open court. Centuries of common law litigation have shown that confession is the weakest kind of testimonial evidence. It is also shown, however, that confession in an open court is an exception to that rule. Indeed, the gravity of the common law's adversarial courtroom, holding fast to due process's fair play, discourages confession, thus when made it is reliable. Without doubt, the atmosphere of open court in a common law country is less oppressive than a civil law country's one-sided inquisition. The common law, being adversarial, breathes the air of rivalry, holding fast to due process that demands the dignity of fair play. In sum, because confession is the weakest of criminal evidence, the Constitution allows conviction of treason against the United States on confession, but only if in open court. But without confession in open court, one is convictable, says this clause, only if at least 2 witnesses testify to the same overt act of treason. An overt act is an unhidden act in furtherance of a treasonable goal. It need not be an unlawful act if intended to further treason. Thus, a single testimony to each of the defendant's several overt acts of treason will never convict. In fact, even a train of single witnesses, each testifying to a different link in a chain of acts planned to betray the United States, falls short of enough evidence to convict a defendant of treason. Oh my goodness. In addition, evidence of talking or thinking about doing treasonable act taken alone is never enough for conviction of treason. Indeed, our common law punishes criminal acts. Mere thoughts and speech hate or malice are not crimes before our courts of men. In fact, Amendments 1 and 5 protect us from government prosecution for thoughts, conscience, and speech. Finally, this clause, by requiring 2 witnesses to establish any material fact to the charge of treason, follows Scripture. At least 2 witnesses, any having direct knowledge by way of his 5 senses of the fact to which he testifies, are necessary to establish every arising matter, i.e. issue Hebrew. An unproven accusation or question of relevant fact, visual issue. See Deuteronomy 19:15. In 2 Corinthians 13:1, the apostle uses rhema to denote the Hebrew phrase yakun devar. Therefore, a rhema is that which is yet unproven. Used in the Roman civil law tradition, rhema denotes a bold accusation, an unproven account in an indictment. See generally Brent Allen Winter's Excellence of the Common Law, Application 2.9, contrasting the civil law Greek terms rhema and logos. Section 3, Clause 2. The Congress shall have power to declare the punishment of treason, but no attainer of treason shall work corruption of blood or forfeiture except during the life of the person attained. Comment: the phrase no attainder of treason shall work corruption of blood means that the family of a traitor will never share his guilt before the law. Formally, a traitor's innocent family member could also be punished and otherwise made to suffer by forced deprivation of property and denial of inheritance rights. This clause bars against corruption of blood accords with Ezekiel's confining of guilt to the wrongdoer. The soul, the one sinning, it shall die. Ezekiel 18:4. See also Deuteronomy 24:16. And that is where we will stop for this reading. And I will see you on the next call. Peace and love.